Appeal Stanford Appellants Limited, Bank Limited, Dublin.
Yes, Ms. Parisa.
I appear with Mr. Ulgar and Mr. Sanasi for the appellants. Mr. Person and Ms. Jeetham and Ms. Elia appear for the respondent, AfrAsia Bank. Mr. Sozi and Ms. Paré appear for the first co-respondent, the Financial Services Commission of Mauritius. The second co-respondent, the Financial Intelligence Unit, is not represented, but we understand that it wrote to the board on the 21st of May, informing it was happy to abide by the decision of the board. The third co-respondent is not appearing. My Lord, there are 5 issues on this appeal, and they broadly reflect the 5 grounds on which the appellants obtained leave to appeal from the Supreme Court, and they're set out in the main bundle at pages 507. But if your Lordships have got the small key documents bundle, which is very helpful, it's at page 6 and 7 of that bundle. And your Lordships will see the 5 grounds set out on page 7. Your Lordships, however, may have appreciated from reading the parties' written cases that there is a very significant degree of agreement between the parties on the issues this morning, in light of which we say there is a very clear and welcomely short way through for the board to grant the appellants their relief, if your Lordships are so minded. But before I look at the parties' positions, may I quickly just take your Lordships to the background facts. They are set out in the agreed statement of facts. Again, they're pages of 1 to 6 of the key documents bundle. And I don't know if your Lordships want me to take you through them.
I don't think that's necessary, thank you.
My Lord, may I just make a couple of points from them? The key ones are, first of all, the wrong occurred in Mauritius, and the action sought to be initiated will be in Mauritius if the information is obtained. So we're not seeking aid in support of foreign proceedings. The information sought can't be obtained by my clients otherwise than from the bank. The notice of motion, which is at page 4 of your Lordship's main bundle, the information sought there is very focused and very narrowly framed. This is not a fishing expedition. It's akin to that routinely sought by way of Norwich Pharmacal applications in this jurisdiction and in other jurisdictions. And it's totally in line with Mr. Justice Saini's decision, as he then was, in Collier and Bennett, which your Lordships will be well familiar with. As your Lordships will appreciate, none of the other parties opposed the orders sought by my clients. It was rejected by the court, and their judgment is in the key bundle, and it's at page 324. So as matters currently stand, my clients are without any meaningful remedy. They had made 3 other prior applications on slightly different grounds. Those were all rejected. And as your Lordships will appreciate, they have notified the authorities, but no action has been taken and no criticism is made of the authorities. What your Lordship may not appreciate that the FSC has the information that we're seeking, but it is not prepared to hand it over to us. So the position today is, in summary, that all parties agree that the Mauritian Supreme Court has the power to make the order that we seek. My clients and the first co-respondent, the FSC, agree that Section 64 of the Banking Act 2004 doesn't exclude freestanding Norwich Pharmacal relief, and the respondent, the bank itself, also appears to accept that as a fallback position, and I'll make that good in a minute. No one today opposes the grant of the order sought on either of the grounds relied on by the Supreme Court to deny the order, namely the alternative remedies exist or the public interest as regards law enforcement. And for completeness, both the appellants and the bank agree that the order sought could also be granted on the basis of 64(3)H of the Banking Act, although the FSC opposed that route.
Yes, and in that event, you'd have to issue a summons against a person falling within subsection 1.
Yes. So we say, with respect, that there is a very simple route through for the board to grant the appeal today on this basis. We say, first of all, that Norwich Pharmacal relief is not excluded by Section 64 of the Banking Act. A position, as I've said, is largely common ground and tacitly, if not expressly, accepted by the Supreme Court. That's our ground 1 of appeal. Secondly, there's no special weight to be given to banking confidentiality. That's ground 3 of our appeal. And in either case, there are no discretionary reasons not to grant the relief. And that's ground 2 of our appeal. And whilst we apply for relief under the various provisions of the Mauritius Banking Act, grounds 4 and ground 5, we don't need, we respect, to rely on those today if the board is with us on grounds 1 to 3. And so I intend, with permission, to focus on why we say the board should make an order for freestanding knowledge form of the relief. Perhaps before I do so, I should make good the parties' respective positions on the written cases, if your lordship need me to do that. Let me just show you the respondent's written case. Your lordships will have that. It's in the small bundle of documents behind tab 3.
Ms. Provisa, I'm operating entirely on an electronic.
I'm sorry.
And I find it quite difficult, I don't quite know why, to have both the key documents bundle and the main hearing bundle on the screen at the same time.
I'm happy to work on
I shouldn't
the main
have that
bundle.
problem, but I do. So if you could possibly give me main bundle page numbers, I would be extremely grateful.
I apologise. My lord, the respondent's statement of case is at page 547 of the main bundle. And your lordships will see at paragraph 2 that they don't object to the application. So that's a good start, we said. Its view was that the application was correctly made against us again under section 64(3)(h) of the Banking Act, and you see that from paragraph 3A on page 548.
But you didn't issue a summons against any person falling within subsection 1, did you?
Yes, we say that we are in. We do. I'm sorry, I can.
I thought you sought an order against the bank. Did you seek an order against individuals?
Well, we seek an order against the bank.
Yes.
We say that the bank only acts by its individuals, and I'll come on to...
Yeah, but you make the point yourself that subsection 3H isn't concerned with the bank.
Well,
In fact, section 64, it may be, isn't concerned with the bank.
Well, look, we say we don't need to go to section 64(3)(h). If your lordships are with us on grounds 1 to 3, which is the freestanding Norwich pharmacal relief against the bank itself. If your lordships are against us on that and we need to rely on 64(3)(h), my lord, we do say that the legislator intended that it should be against the bank, that should apply for the bank only being able to act by its agents, individual persons, employees, in those circumstances.
Yes, but is it common ground that section 64 has nothing to do with the bank?
I don't think it does, is because the respondent's application, the respondent's case, if your lordships look at 5483A, the bank accepts that the application was correctly made under the Banking Act, under H.
But you can't make an application under 3H against the bank, can you? I mean, you just read what it says.
Well, I think the bank accepts that the bank can only act by its individual agents.
Yes, but if you, I mean, the logic, I wonder if you're making life unnecessarily difficult for yourself. 3H applies where any person referred to in subsection 1 is summoned to appear before a court. Now, the persons referred to in subsection 1 are every person, including a service provider, who by virtue of his professional relationship with a financial institution has access to the books, etc. And if it weren't clear enough from that the financial institution itself is not such a person, what subsection 1A does is to impose a duty to take an oath or to make a declaration. So I think it mustn't it be dealing only with natural persons?
Well, my lord, we say that is not correct, because 64(1) talks about every person, including the service provider, and I accept that it talks in terms of persons.
Yep.
But the primary duty of the banking confidentiality is clearly between the bank and its customer. And it would be...
But non-constat, that's what Section 64 is concerned with.
Well, my Lord, I hear what your Lordship says, and that your Lordship's point is that given that that 64.1 is concerned with the individuals taking the oath, what then follows relates to the individual position and not otherwise. With respect, as I said, which,
if I may say so, from your point of view, is with one bound you are free.
Well, my Lord, I won't push the point further, but my Lord, we do focus today mainly on the freestanding Norwich pharmacal relief because we have no alternative remedy against the bank, and we do say that it has been long recognised in Mauritius and in various other jurisdictions that the same equitable remedies that are available from the High Court in this jurisdiction are available from courts of equity elsewhere, including in the Mauritian court. My Lord, if I can take your Lordship through where I was in terms of showing your Lordships where other parties stand on this appeal, because it's quite important that you see the commonality. As I was looking at the Respondent's case, my Lord, they don't object to the application. You see that at 2. They do put it under 63.4.3h at paragraph 3a. They say, the bank, that the Supreme Court did not explicitly hold that Norwich pharmacal relief was excluded by 64.3h. They say that at 5.5.7, paragraphs 52 to 54, my Lord, of their written case. But they then go on to say at page 559 that if they are wrong about 64.3h, then they accept that the court should be able to grant Norwich pharmacal relief in the exercise of its equitable jurisdiction. That's paragraphs 66 and 68 of the bank's written case. And then finally, the bank agrees with us on the alternative remedies and the relevance of the law enforcement investigations, namely that neither of those preclude the grant of Norwich pharmacal relief in the present circumstances. And that's at paragraph 81 of my learned friend's written case. That's at page 562. For completeness, as I've said, the bank disagrees with us on the operation of 64.10. It accepts the Supreme Court's decision that 64.10 needs to be read with 64.9. As regards the first co-respondent's position, your Lordships will find their amended statement of case at 1217 of the main bundle. Overall, they say at paragraph 3 they are content to abide by the decision. They submit at paragraph 9 that 64.3h doesn't permit our application. They take the same stance with regard to 64.10 at paragraphs 12 to 13, but importantly for present purposes, and this is at paragraphs 15 to 18, they appear to accept that Norwich pharmacal relief could be granted, and they don't submit that it's excluded by section 64. And as I've said, the FIU doesn't appear that is agreed to be bound by the board's decision. So if I may then go on to ground 1 of our appeal, and turning to our written case, which your Lordships will find at page 513.
Sorry, 5. Say again.
513.
Thank you.
And as we state at paragraph 8 of our written case, the judgment of the Supreme Court on the question of freestanding Norwich pharmacal relief is not, with respect, entirely clear. Because if your Lordships go to the judgment, which starts in the main bundle at 324, but if your Lordships then go to 353, the Lordships see the court appears to acknowledge there the existence of the Norwich Pharmacal jurisdiction in Mauritius. You can see that in the second main paragraph. And we would say rightly so, because as we say in our written case, and your lordships will appreciate, Mauritian law borrows very heavily from English law as regards interim remedies, and one sees that from this board's own decision in the jackpot case against the gambling authority. And for your lordships, if your lordships wishes to turn that up, that is in page 1123 of the bundle. And your lordships will see that the decision there. And Lord Briggs will be well familiar with this decision. And the paragraph that we rely on is paragraph 8 on page 1129. So the Mauritian law borrows heavily from English law. In addition, section 16 of the Courts Act, 1945 as amended, which is in your lordship's bundle at 638.
Sorry, just before we leave that.
Yes.
What exactly do you say paragraph 8 is telling us?
What it tells you is that the Mauritian law is grounded in English law and uses English law legal taxonomies, and that it bases all matters which are not criminal. So it's simply that this is the origins of the Mauritian law and in civil proceeding.
Just really the first sentence?
Yes.
Yeah.
Yes, absolutely. And section 16 of the Courts Act in Mauritius 1945 as amended, which is in page 638 of your lordship's bundle, provides that the Supreme Court of Mauritius is a court of equity, and the Mauritian courts have frequently recognised that they have the same powers as the High Courts of England and Wales to grant injunctions and other equitable remedies. And again, the jackpot decision recognises, and we've referenced it, that the Mauritian legal system has the advantage of drawing on both French and the English system. The Mauritian courts, in your lordship's bundles, we've included decisions where the Mauritian courts have recognised the availability of freezing orders and anton-pillared orders. And one particular decision we rely on is at page 1041 of your lordship's bundle, is the Tervagandum judgment. If your lordships would like to quickly turn that up. This is a case that concerned an ex parte waiver order and disclosure. And the particular passages on which we rely start from 1044 to 1046, dealing with the Moreira jurisdiction. And going over the page in 1046 specifically. And we've also referred, your lordships, to the decision in the Barclays Bank Mauritius case in Karamouth, which the Supreme Court also referred to. And that's also in your lordship's bundle at page 1066. And that, again, was another Moreira case where the court granted freezing orders with ancillary disclosure order. And so we say, by parity of reasoning, that the Mauritian law should also recognise the existence of a freestanding Norwich pharmacal remedy.
There's no actual decision in which they've made such an order, is there?
Is there actually a decision?
There's no decision in which they've made a Norwich pharmacal order.
There is a decision, my lord. There's a decision in Global Aluminium against Mauritius Revenue Authority, which is in your lordship's bundle at 1114, where the court acknowledges that such relief is available, but on the facts didn't grant that. If your lordships want to turn that up, then that is in your lordship's bundle. The problem with respect to the court's decision in this case was, whilst appearing to acknowledge the existence of Norwich pharmacal relief, between pages 350 and page 353 of the judgment, the court appears to have concluded that the disclosure orders made in the two decisions that were cited to it, in Karamuth and Lee Tung Sam, were not clearly made on the basis of freestanding Norwich pharmacal relief. And the court cites the decision of Fundum, which is in your lordship's bundle at page 351, as appearing to question whether the common law principles enunciated in Norwich pharmacal would actually apply in view of the provisions of the Banking Act. And your lordships, having read the Supreme Court's judgment, your lordship will also see what they also treated the existence of other statutory schemes as demonstrating that there was no exemption in respect of Norwich pharmacal relief.
Just before we leave the sort of inherent jurisdiction,
Yes.
That is confirmed, is it not, by the Courts Act, by various sections of the Courts Act?
Yes.
So this is section 16 and 17?
Yes. So the problem with the present judgment is that, having referenced the freestanding Norwich pharmacal relief, it then questioned whether, in fact, the disclosure orders that had been made in previous cases were actually made on that basis. And they also referred to the existence of other statutory schemes as suggesting why no Norwich pharmacal relief should be available. And in light of the Supreme Court's holdings with regard to the alternative remedies that are meant to be available to us, with respect, we say it's difficult to conceive of any case where somebody could obtain Norwich pharmacal relief where they had reported the fraud to one of the authorities. And what the interpretation adopted by the Supreme Court in their judgment does is effectively deprive the appellants of any private law remedy. Now, I need to take your lordships to the Banking Act itself, and if I may do that.
Just before we go there,
Of course.
is the argument effectively exactly the same whether we're talking about a Norwich pharmacal order or a Bankers Trust and Shapira order, or, if there's something else, a disclosure order consequent on
We say it's exactly
a freezing
the same.
order?
We say exactly the same.
So the Court of Appeal decision is effectively ruling out all those on your understanding?
Well, it doesn't on its face go so far, but yes.
But the reasoning
on parity of reasoning, yes.
Yeah. Well, it would rule out a freezing order if accompanied by the usual provisions for disclosure.
Yes. That's exactly right.
Yeah. And without those, it might be said not to be worth much.
And it has made freezing orders with disclosure orders attached are made in Mauritius, albeit not frequently, and certainly not. They're not as commonplace as they are here, where the disclosure orders are part of the Commercial Court Guide standard order now. My Lord, let me if I may, take you to the Banking Act itself, because I think it's important to see its wording. That's at page 627 of the bundle. And we do say that Norwich pharmacal relief is not excluded by the clear wording of the Banking Act, and you would need clear wording to exclude it, because Section 64 was enacted against the background of the existence of a Norwich pharmacal remedy. It's at 627 is where 64 begins, and it's concerned with, we say, establishing and codifying banking confidentiality owed by banks and agents of banks to their customers. In effect, it's putting into effect the Tournier principles on a statutory footing. And your Lordship, Lord Reid mentioned 64.1, which talks about every person who works for a bank or has some professional relationship with a financial institution and has access to books requiring to take an oath of confidentiality.
Something's gone wrong with the syntax, grammar
Yes.
of subject 1A, because, I mean,
Yeah, the comma should appear after provider rather than institution, I think.
That's absolutely right.
and even then it's odd, because one wouldn't describe an ordinary bank employee as necessarily having a professional relationship with the bank, but one would be, I'm tempted to say gobsmacked, if they were somehow to be regarded as excluded.
We agree, my lord. The drafting of this Act leaves a little to be desired, and there are other instances where...
I mean, we must make the best of it we can, because an important... I mean, this particular grammatical problem affects whether Section 64 applies to orders against banks at all.
Yes. And your lordship will see 64.2, which is at the bottom of 629. 64.2, which codifies the banking confidentiality. It says, except the performance of the duties or exercise of functions under the banking law, no person referred to shall disclose any person any information of any of its customers. Well, it's the bank's customers rather than the individual's customers, including any deposits.
Well, yes, but the it surely is governed by financial institution.
Yes.
Yeah.
So that your point doesn't go anywhere, does it? I don't see where your point goes if that is the case.
No, my lord, I was simply saying it said shall disclose directly or indirectly to any person relating to the affairs of any of its customers, the banking institution's customers. And then going over the page, it says the duty of confidentiality imposed under this section shall not apply where? So that's 64.3. So 64.1 and 2, we say, apply not to banks but to natural persons acting as agents for the bank on its face. Section 64.3 disapplies then the duty of confidentiality in certain defined circumstances, and your lordships will see by scrolling down from 3, those defined circumstances are varied. Some concern ordinary incidents of litigation. You can see that at 3D and G, where a garnishee order has been served. Some fulfill regulatory functions, J and K, and
these are duties, I mean, as I understand it, we see it under 1A, the natural persons who are covered by that provision are required to take an oath of confidentiality or a declaration, or make a declaration. So they are doing this as individuals.
but in their capacity as agents of the bank. The bank.
No. You don't take an oath in the capacity of an agent. You take an oath as an individual.
Yes. No, that must be right, my lord.
We don't actually. I don't think we have the oath or declaration themselves. But
does the apparent exclusion of the bank from subsection 1A, and with all the provisions about taking an oath, get watered down a bit by one little AB on page 628, which is notwithstanding A and AA, the central bank may, where the circumstances are right, require a financial institution or a service provider to comply with confidentiality requirements that it may specify in guidelines, directives or instructions. And a fair reading of AB is that if that's what happens, then they're given statutory force and are treated as part of the confidentiality regime under subsection 1.
I think that must be the correct reading, my lord. Of that.
And if that's right, I don't suppose anybody's explored whether the central bank has given banks any such guidelines or directions. But that might then cause one to rethink slightly how the exceptions in subsection 3 work.
Yes, as extending beyond the individuals who have
to
given
the bank
yes.
itself. And I'm just
Yes.
probing just how firmly one gets the view that this is only about people, individuals, rather than the bank.
Well, my lord, we see the difficulty with the
Well, I wonder about that because under 1A, the duty is to take an oath and presumably to comply with it.
Yeah.
AB is enabling the central bank to require a financial institution to comply with such confidentiality requirements as it may specify in guidelines, directives or instructions to be issued by it. So it strikes me as being separate from 1A, that you would have to look at the relevant guidelines or whatever in order to find out the content of the confidentiality requirements that were imposed.
I mean, my lord, we acknowledge there are difficulties with the wording of section 64 as drafted. We acknowledge that the confidentiality relationship implicit on the banking relationship is between the bank and its customer. The individuals who are caught by 64(1)A are those working or in some form of professional relationship with the financial institution.
Well, it's tighter than that. If you look at B on page 628, professional relationship is defined. Yes. Any relationship between a financial institution and a service provider of which the central bank has been made aware.
Yes.
So that's not an ordinary employment. On the face of things, it's not an ordinary employment relationship.
No, Your Lordship is right. And when you
one gets the impression that this has been legislated to deal with a particular problem or abuse, of which, unfortunately, we haven't got the historical A to Z.
Well, I think my
and
lord,
it's strongly about service providers.
yes.
Because it's tightened up. It's far more specific than the Act as originally enacted, which we have at 618.
Yes.
Which was simply every person having access to the books of a financial institution.
Well, my lord.
So the amendments made in
Section 39.
Well, the most recent amendment was only last year.
Yes, that's absolutely right.
That seems to be the one that inserted the definition of professional relationship.
Do we know whether that was before or after the Court of Appeal decision?
Do we know?
I mean, they weren't relying, were they? I don't think they were, on the definition of professional relationship in B.
No. There's no suggestion that they were.
The point that we're raising with you is one that simply wasn't discussed below at all.
No.
I mean, the focus seems to have been on 1610 and 16.3H, which might be described as looking through the wrong end of the telescope.
Can I suggest a possible resolution of this? If you compare 64(1)A in its present form with its previous form, I wonder if a who hasn't got missed out or has access to, because the previous one applied it to anybody who had access to the bank's books, which makes perfect sense. One can well understand that the reform which we see as new in 64(1)A to introduce restrictions on service providers was intended to toughen the regime by bringing in service providers, but it surely wasn't intended to throw out, as it were with the bathwater, everyone who has access to the books and accounts of the bank. But without sticking in a who there, it's difficult to know how they stay in.
Yeah.
Well, if you had two who's, it doesn't make grammatical...
I know, but it's better than having one and a half.
Two who's doesn't make grammatical sense.
Well, I'm not sure. Every person, brackets, including a service provider who by virtue of it has with a financial institution.
Oh, I see, you put in brackets.
Who has access to the books and records.
Yes.
It won't at least make sense.
But then you don't have a verb after the first who. You know.
Well, no, I know. has such access, who has access. I mean, it's intolerable, but what seems to me to be fairly clear is that there wasn't an intention to exclude those who were under confidentiality under the Act as it was before the specific regime for service providers was brought in.
Yes.
It would be bizarre, it seems to me, if that was what was intended.
I think that's right. I mean, where we go on this is to say you would need clear words to exclude the equitable Norwich pharmacal relief that is available and was available prior to this Act being...
Yes, but if the Act doesn't apply to the bank, you don't need to exclude a Norwich pharmacal relief at all.
No.
There's also the problem with the final words of 1A, before he begins to perform any duties under the banking laws, because one might think that the service provider, for example, might be an IT consultant,
Yes.
who, I mean, unless the banking laws are different from what one might expect, the service provider wouldn't be performing any duties under the banking laws.
No, your Lordship is right.
Is the banking laws a defined term?
Is the banking...
The phrase "the banking laws" a defined term?
Yes.
Yes. I think, yes, it
Yes,
is.
in B.
Well, it includes the National Payment Systems Act.
And that was in the old Act. I mean, that was in the Act before amendment.
Yes.
Page 619.
So,
I'm being told the amendment was the 2nd of August 2022, so post-argument but pre-judgment.
it's a single set of amendments, is it, that both adds 1A and 1B and adds the words in 1a.
Yes.
Sorry, not 1a, in 1 itself.
Yeah, the service provider word.
So,
And then I was looking, had just got to look at 64.3, that wording, before we get on to 8, which talks about the duty of confidentiality generally imposed under this section. Begging the question on whom. And then...
well, yes and no. Once you've formed a view on what 2 means, 3 would fit either, wouldn't it? Although it might be thought there are some bits of it which are more appropriate to individuals, such as H.
But my Lord Briggs is right. The submission I was making, which is there's no, on its face, it doesn't purport to restrict a pre-existing right to obtain disclosure relief. If it's not aimed at the bank at all, then I don't even need to go that far. I'm going, just while we've got the Act open...
and I hope you'll deal you focused on H, but we've mentioned a difficulty with that. But you might also deal with D. D. Because it might be arguable that that's, if we're concerned with Section 64 at all, it might be argued that little d, 3D applies.
Literally, it's extraordinarily wide.
Yes.
I mean, apparently it's a complete disapplication of the confidentiality duty the moment the bank and its customer are in any form of civil proceedings, even if it's an ordinary sort of summary debt claim by the bank against the customer.
Do you understand? Yes. I mean, we had read this as referencing civil proceedings between the bank and its customer, and not therefore relevant to the present instance.
That's not what it says. It says involving, isn't it? It sounds as though I appreciate you've got a quick route one, as it were, to the answer that you want. But we need to explain, for the benefit of the courts of Mauritius, so far as we can, what the correct interpretation of this legislation actually is.
I appreciate that, my lord. Can I just finish, just as we've got the Act open, looking at the other sections that have raised on this appeal, which is 6410, which is on page 635, and 64.9, which is on page 634. And your lordships will see that contains a specific provision in relation to applications to judges and chambers. And the question for our secondary cases then is whether 9 and 10 need to be read together, such that the latter provisions are limited to law enforcement agencies. And Mr. Sanassi is going to deal with that. But we do say, standing back and reading these provisions as a whole, there is nothing, we say, in section 64 that purports to limit the equitable relief available, and that the Supreme Court was wrong with respect to construe 64 as an enabling provision creating powers to order disclosure, which would displace existing legal basis for such disclosure orders. We say it's plainly not an enabling provision, maybe perhaps save for 6410. We do say it's principally concerned with the statutory basis for banking confidentiality and then specifying exceptions thereto. And we do say, and it's the main thrust of our submission, is that the right of a private litigant to seek disclosure doesn't need to be created by statute. It existed prior to the Banking Act coming into force by reason of Norwich Pharmacal principles. And our construction is, we say, consistent with the presumption against legislative interference with the rights of legal process. Access to the court in Mauritius is a fundamental constitutional right, and litigants should not, without clear authority, be shut out from that access. If I may go quickly to our written case, which your lordships will have read on our ground, and particularly from paragraph 40 to 48 of our written case, which is at page 527.
527 or 53?
527.
Thank you.
In particular, focusing on the cases which have considered the availability of disclosure relief against banks by private litigants. And your lordships will see we refer at paragraph 41 to the Rogeo case. It's at page 1176 of your lordships bundle. And if your lordships will turn that up for a minute. And in particular, the passage that we rely on is at 1177. This was dealing with a court making an order under section 64's predecessor, that's section 39(2)d, in favour of the children of a mother's estate. And your lordship sees on 1177, it talks about 39(1), prohibiting the disclosure by an employee or agent of a bank of any information relating to the customer's account, and then providing the duty of confidentiality shan't apply in certain circumstances. And then, according to cursus curiae, in Mauritius, the judge in chambers has normally entertained applications for disclosure, presumably on the construction of that provision. So that's simply a case where, under the previous law, disclosure applications have been made by the court. The other decisions we refer your lordship to are the Lee Suk Hong Lee case, which is referred to by the Supreme Court in its judgment. That's at 1135 in your lordship's bundles. At 1135, this was an application for disclosure of information in respect of bank accounts held by a co-respondent with the respondent banks. And the Supreme Court refers to this in its judgment. And if your Lordship goes to 1137, where there is a reference to the Norwich Pharmacal Principles, and also to the Bankers' Trust Principles, and we've highlighted the passages on 1137 to 1138, where the court rejected the idea that Section 64 only applied if one of the parties was a public body or a financial institution. And your Lordship will see the paragraph just below, where they deal with Section 63G and H. So, although the Supreme Court in the present case queried whether the disclosure order in that case was actually made on the basis of Norwich Pharmacal Principles, and it said that the court didn't examine whether the conditions required for the issue of the Norwich Pharmacal Order had been satisfied, what one sees at 1137 to 1138 is that the court clearly considered Norwich Pharmacal Principles alongside the Bankers' Trust Shapiro Principles, and at 1140 appears to have reached the conclusion in favour of granting relief based on those principles. Although I think it is clear to say that they are based more on the Bankers' Trust Principles at 1140 than the Norwich Pharmacal Principles.
But you don't suggest that such differences in those principles as there may be makes any difference to the outcome?
We don't say it makes any difference. My Lord, I've also referred in our written submission to the Barclays Bank and Caramuth decision. That's in your Lordship's bundles at 1066.
Before we leave it, is there any reason why one has gone down the Norwich Pharmacal route rather than what might seem marginally more appropriate, which is the Shapiro route? Is there anything?
I don't think there was any specific reason why they went the Norwich Pharmacal route. It was the relief sought was standard Norwich Pharmacal relief. Actually, when one looks at the notice of motion,
right,
the information that was sought was not bankers' books and records, but the names and identities of the account holders and the authority of the person who paid away the money in pursuant to the alleged fraud. So I think the Norwich Pharmacal relief sought was more appropriate. I was turning to the Caramuth case, which again the Supreme Court refers to, and that's at 1066. That is a Morava case, or a worldwide freezing order case, where ancillary disclosure was sought. And if your Lordships will look at 1074, please, in that judgment. Your Lordship sees that the court cites with approval the Norwich Pharmacal jurisdiction as a freestanding basis to make an order for disclosure against a bank or financial institution. And finally, also in support, we have provided your Lordships with the decision in non-inducing against Standard Bank at Mauritius. That's at 1164 in the bundle. This was an application made under Section 63H, where the court granted disclosure in favour of a private party against a bank under that section, relying on Rojoa. And your Lordship see that at 1165. They set out the section on 1164, as your Lordship will see, and it's halfway down on 1165.
I may have misunderstood you, Ms. Provisor. Were you saying that these authorities you've cited so far support your case on ground one?
Well, what they show is that the Mauritian court acknowledging the existence of freestanding Norwich Pharmacal relief.
But they're not granting freestanding Norwich Pharmacal. What they're doing, surely, is applying what they think are the provisions of Section 64, but in the decision whether or not to grant relief under those provisions, looking at Norwich Pharmacal principles.
Yes.
But that's inconsistent with your ground one.
It's not wholly inconsistent. What they acknowledge is that there is an equitable jurisdiction. Your Lordship is right that what they appear to be saying is that you go through the gateway of Section 64, and then in the exercise of the discretion, you apply Norwich Pharmacal principles on whether to grant the order for relief sought. Your Lordship is absolutely right on that. Now, the principle...
Is it any part of your submission that 64(3)H actually confers some new jurisdiction on the court? Because read in context, it just appears to be one of a large number of instances where there is a gateway in the confidentiality duty.
My Lord, our alternative case it does, our primary cases it doesn't.
No, okay.
The principal contrary decision, which the Supreme Court in the present case referred to, is the Fundum decision. That's at page 1142 of the bundle. And your Lordships will see again it's a Section 64 case. And your Lordships would, if your Lordships will look at, it's at 1142, but if your Lordship looks at 1148, dealing with the application under Section 64, the applicant invokes the principles in Norwich Pharmacal, and then what is found on 1149 is that Section 64 is a comprehensive piece of legislation designed by virtue of its structure a scheme to deal holistically with the issue of confidentiality, sets out in detail the limited circumstances and conditions subject to which there may be a disclosure of any information relating to the affairs of the banking customer. And so you had to bring yourself strictly within those provisions. And then, just reading on in that decision, at 1152, at the bottom of the page, necessary to determine whether the common law principles establishing Norwich Pharmacal can be resorted to by our courts, and if so, in what circumstances. It goes on to say the Banking Act has provided specific instances where disclosure is permissible, and then the questions arise whether it's a comprehensive statutory regime.
So sorry, are you reading from 1152?
1152, the bottom paragraph, my Lord, going over the page on page 1153.
Oh, I see, yes, sorry.
Dealing with this question of whether the Banking Act provides a comprehensive and exclusive, effectively, regime, says, is the Banking Act a comprehensive statutory regime which covers exhaustively the whole question of confidentiality? So it precludes the application of any alternative common law remedies, such as Norwich Pharmacal itself. And then it says, this will no doubt require a close examination of the relevant sections of the Banking Act in order to determine whether a disclosure of such confidential information may only be obtained via the statutory channel prescribed under the Act. And then going over the page, it refers to the Lee Soup on Lee case. And then down on page 1154, penultimate paragraph. Although the decision in Norwich Pharmacal provides some useful insight as to the approach which the court would adopt for allowing discovery of information in the course of the civil proceedings, the matter stands governed essentially by the express and detailed provisions of 64 of the Act, which succession has invoked in support of the application. In any case, Norwich Pharmacal reorder is not warranted in this case. So even if it was, they weren't prepared to grant it. Now, this decision with respect stands alone against earlier authorities.
It's the same judge as one of them in our case.
It is.
I'm sorry, am I misunderstanding you? I thought it's consistent with the previous authorities for the reasons I put to you before. It's just drawing out the implications of them perhaps a bit more clearly.
It's consistent in terms of the proposition you have to go through the gateway of 64 and then consider Norwich Pharmacal principles in exercising the discretion.
But that is contrary to your ground one, isn't it?
It's contrary to our ground one.
Yes. So this isn't a departure from what they've been saying before. It's making slightly clearer what is actually clearly implicit in what had been said before.
This is the Supreme Court in the present case relied on this, or referenced it, and didn't go much further than this, as saying that the Section 64 provided a complete regime in respect to confidentiality.
But it's inconsistent with the previous decisions in that they thought you could use the gateway to get to Norwich Pharmacal.
Yes.
This is precisely saying you can't use 64 to get to...
Well, I'm not sure it is going. What it's saying is you have to bring yourself within the gateway of 64, that it is a comprehensive piece of legislation.
Yeah.
And if you bring yourself within that, then Norwich Pharmacal principles provide insight on the approach to be taken by the court in whether to grant the relief.
Yeah. And the earlier cases, I think, had relied on a number of provisions. One, I think, was one or two of them were 3H, but another one was the provision dealing with garnishee orders under 3G.
The problem with this case, with respect, is that it is not thoroughly reasoned. The court's attention wasn't drawn to the fact that Section 64(3)H effectively restates the position at common law. It appears to introduce a restriction which isn't, we say, borne out by the drafting of the section itself. And picking up a point my Lord Briggs made, is that the conclusion is inconsistent with the policy behind Norwich Pharmacal in allowing an innocent person to assist the victim of wrongdoing by giving disclosure. And it would be incongruous result if Norwich Pharmacal would be available except where a bank is involved, because that is effectively where this ends up. And with respect, we say it is an outlier in that regard.
It'd be more incongruous in a banker's trust situation.
Absolutely. And we say there ought to be no distinction between those two equitable remedies. And in the same way, we say the decision that the court referenced in Express Gold Refining Limited, the ex parte case, which is at 1097 in your Lordship's bundle, where the court, apparently without citation of any authority, held that Section 64(3)H didn't allow for a private applicant to seek disclosure, but only applies to persons subject to a duty of confidentiality under Section 64(2). Your Lordship see that on page 1099.
Isn't that clearly correct? The 3H only applies where any person referred to in subsection 1 is summoned to appear.
But, my Lord, your Lordship is right. If your Lordship is of that view, then this is consistent with that. So those are the principal authorities to which the court was referred. We say, standing back, there are 4 policy reasons in support of our interpretation and how we say your Lordships can move forward on this, is that, first of all, in general, Norwich Pharmacal relief, as is well known, is a critical weapon against fraudsters, and it's commonplace in this jurisdiction and in other jurisdictions from which appeal lies to this board. And we have provided your Lordships with an appeal from the Eastern Caribbean Supreme Court at page 942, a decision both on Bankers Trust and Norwich Pharmacal relief, just by way of example. I don't think it's necessary to turn your lordships up, and your lordship will be well familiar with the jurisdiction in other, the existence of the jurisdiction in other jurisdictions other than Mauritius. We say the approach of the Supreme Court effectively leaves no remedy to somebody in my client's position because it can't trace and therefore freeze its funds in the hands. It would leave Mauritius as an outlier where a person is wholly dependent on law enforcement to trace funds. And we do say it is unlikely that the information being sought is in fact confidential. Because, as your lordships will know, a fraudster is disentitled from relying on the confidential relationship with their banker by reason of the fraud. And we rely on the decision in the SBM Bank Mauritius case for support of that proposition. That's at 1179 in your lordship's bundle.
Sorry, just for my note, are all these still parts of your first point?
Sorry?
You said there were 4 points.
Yes,
They
I've got
were all
one more.
one, still the first.
More. I just would ask your lordship to look at this authority in support of the third point, which is at page 1179, and it's paragraph 26 of this judgment.
Page. Looks like
And
194.
it's the citation of, to the effect that, the reason why we cited this is to the effect that the passage on paragraph 27, which is the decision of Lord Denning and Lord Farnacle, which is then cited with approval, which is the customer who's been prima facie guilty of fraud cannot bolt the door against him. He's disentitled from relying on the confidential relationship between him and the bank. So there is a primary question as to whether the information itself is confidential. And the fourth reason that I said there were 4 is that if the Supreme Court decision is allowed to stand, it would create, for no good reason, we say, an inconsistency with the law on freezing orders, with ancillary disclosure orders that are granted by the Mauritian court. I've given your lordships the 2 Mauritian authorities, the Gandum and the Karamuz decisions, where ancillary orders were sought, weren't made on facts, but were sought, and there was no suggestion that they could not be made. So, my lord, that is our position on ground 1, on the freestanding Norwich Pharmacal relief. And we do say, if your lordship's then with us on ground 3 and ground 2, which I'm going to cover off very quickly, one doesn't need to, with respect, go to section 64, ground 4 and ground 5, but I will obviously cover those off. Ground 3, if I may take before ground 2, no special weight should be given to banking confidentiality. We've set that out in paragraph 69 of our written case, and really nothing more to add on that. In short, if the Supreme Court thought that Norwich Pharmacal relief was available in theory, which it appears to have thought in its, as reflected in its judgment, but banking confidentiality was a weighty reason for it not to be, then we say it is wrong to find that for the same reasons as we rely on for ground 1. And particularly the 4 policy reasons that I've just outlined. And just to a further point that your lordships may not be aware of, the bank is a data controller under the Mauritius data protection. And there is no issue in it providing disclosure of the information under that Act. Ground 2, which is, I obviously do need to deal with, because the Supreme Court held that because we had purportedly alternative remedies, a Norwich Pharmacal relief was not justified. With respect, we have set our case out at paragraph 70 to 78 of our written submissions, at page 539 onwards. And the short points are these. The point about alternative remedies was not argued orally or in writing before the Supreme Court. The court didn't raise the suggestion that it would refuse the application on discretionary grounds on the basis of alternative remedies. Norwich Pharmacal, as your lordships know, doesn't have to be a remedy of last resort. It doesn't need to have an alternative remedy. There was, in any event, on the facts of our case, no straightforward way of us getting this information in order to trace our funds. And with respect, this case is on all fours with the decision of this board in the President of the State of Equatorial Guinea, an RBS, which is at page 996 of your 96, I do apologise, of your lordship's bundles.
Or 996?
No, 966, my mistake.
966, sorry.
Yes. If your lordships just quickly turn that up, please. And this was a case that concerned the setting aside of a Norwich Pharmacal order against RBS by the Court of Appeal in Guernsey, and the information was sought to find out who were the funders of the attempted coup to overthrow the government of Equatorial Guinea. And the passage that we rely on of importance is paragraph 16, where the court considers whether the test of necessity is applicable, i.e. whether it's necessary, and cites that the word necessary, the test is in final analysis to enable justice to be done. And you see that just towards the bottom of page 970. And we set that out at paragraph 74 of our written case. So in order to be relevant to the exercise of the court's discretion, an alternative remedy must enable a party to find out the identity of the wrongdoer, and in the present case, none of the actions have enabled us to do that, to identify the recipients of the monies or the payments out. So there was an argument by the Supreme Court that there was a public interest in allowing law enforcement agencies to pursue inquiries. We deal with that at paragraph 77 of our written case. It's page 541. The 2 points we would make: we have waited for the law enforcement agencies to take action, and none has been taken. Their law enforcement actions would not be disrupted by a Norwich Pharmacal relief. There is no basis to suggest that my clients would abuse the confidentiality of any information disclosed in a Norwich Pharmacal process. Your lordships may not know this, but the FCU have already got the relevant information, as I said, and haven't disclosed it to us. But we say the fact that there are law enforcement actions being taken or available to be taken is not a bar for Norwich Pharmacal relief being ordered. And in fact, the bank agrees with us on this point in its written case, paragraph 82, at page 562. So if your lordships, we say, are with us on grounds 1, 2 and 3, then the next grounds isn't necessary. Dealing quickly with ground 4, and we've covered a lot of that ground, as your lordships know already. The judgment reasoning, and I understand where your lordships are coming from, was that the 64(1) was restricted to the individuals, service providers, and not to the bank itself. And we do say that it creates an incoherent result with respect, because 64(1) is the primary duty of banking confidentiality. And if their judgment is correct with respect, there is no duty of banking confidentiality generally. It seems to, if your lordships take the view that we don't need to go this route because this doesn't deal with the bank at all, and I can go very short on this, but we do say...
No, I wouldn't make that assumption. But I mean, even if that's right, there's room for argument, at any rate, as to what the position is of the bank's employees, which may be where 3D comes in.
Yes. We we looked at. I think we looked at very quickly the predecessor to 64, which is 39, which in bundle 5 is at 598 to 599, the Lordship's bundle. And it's 39 starting at the bottom of 598. And your Lordship sees it's in pretty broad terms in little 1. No director, chief executive officer, manager, officer, employee or agent of a bank shall, during or after his relationship, etc. And we say it's extremely unlikely that the section 64 was intended to narrow the meaning and remove the bank's actual employees from the definition.
But nobody's suggesting that, are they?
Well, if we're right on our submission that this is intended to capture the bank, in addition the obligation under 64, not just the individuals under 64.1 and 64.2, then it does seem to be suggested by the Supreme Court that this is narrower than 39.
Well, in subsection 1 of the 1980, of section whatever it is of the 1988 Act, the duty imposed by 1, the word shall, the subject of that is what's described for short as a banker. A banker shall, during or after his relationship with the bank. Plainly, the bank can't have a relationship with itself, so the bank cannot be within the definition of a banker.
No, your Lordship is right on that.
But then when one comes on to the exceptions in subsection 2, the first 4 of them are concerned with different types of legal proceeding, and
particularly C suggests that it is concerned where the bank has been served with a garnishee
Yep.
order.
Yes, and B, and B again is concerned with proceedings involving the bank.
Yes.
So if there are certain types of proceedings falling within B or C involving the bank, then the duty of confidentiality imposed on the bankers under subsection 1 doesn't apply.
No. But those proceedings, with respect, are unlikely or never will be against the individuals. The bank managers will always be made against the bank.
But there's a point in your favour.
No, I agree.
Yes, I wasn't clear what you were getting at of that. No. Do I understand correctly that the oath obligation therefore only came in with the 2004 Act?
Yes, I'm being told. Is that right? The oath only came in 2004. I'm told that it certainly didn't come in earlier, but they think it came in with arms in 2004.
Your point about the reasoning in the Supreme Court is that they did seem to be drawing a distinction between employees and other professionals, because this is pages 345 and 346. I mean, they haven't taken the point, as I understand it, that 64.3 isn't applying to the bank at all.
No.
They're taking a different point.
They're taking the point on service providers.
Yeah.
Yes.
Yeah.
And with respect, I don't think anybody below raised the issue that your Lordships have raised, with it doesn't apply to the bank at all.
But even if it doesn't apply to the bank at all, and the court makes a Norwich Pharmacal order against the bank, someone's going to have to make the relevant witness statement or give the relevant disclosure pursuant to the court order,
Yes.
who won't be a person named in the order. I mean, normally speaking, the bank would decide which of its staff
Yes.
go through the process of providing the disclosure. Then the question is, since those people will be subject to the duty in the Act, how they are nonetheless free from it.
They are
And
free,
it would have to be either, wouldn't it?
under 8, they are being summoned. It's
Well, they wouldn't have been individually summoned unless one takes quite a broad view that a notice of motion against the bank is a summons against any employee who the bank might want to discharge the working out of the order, which seems a bit far-fetched.
My Lord, your Lordship is absolutely right that the individual needs to be released to the duty of confidentiality imposed by 64(3).
It may be that the civil proceedings gateway, although not much looked at so far, is the simplest one, because in any Norwich Pharmacal situation, there will be civil proceedings because the application under Norwich Pharmacal is by its nature a form of civil proceeding. And it will involve the bank and its customer or the customer's account if it's an order seeking the sort of information that's being sought in this case.
Well, my Lord, you also get the instance where the civil proceedings have not been initiated. Here, they're anticipated.
But ex parte application is still a form of civil proceeding.
Well, absolutely.
It doesn't say the civil proceeding has to be
No.
between the bank and its customer.
No.
It says involving the bank and its customer.
Yes.
In other words, the subject matter of the civil proceedings is either the banker-customer relationship and in particular, the accounting relationship between the banker and the customer, which this absolutely is about. I mean, it would, on one view, get you around all the problems about the summons.
Well,
On
we
the
had
face
an
of it,
answer
the court isn't summonsing every employee in the bank to come along and provide the information, but it makes a Norwich Pharmacal against the bank.
Yes, I mean, we had we had an answer, we thought, in relation to the summons, which is that the summons, we think, is a red herring in the sense that persons come to the court without the summons may be issued but not served, and a person may attend and still be bound by a court order. And the summons, we say, really adds nothing to the process in and of itself.
Well, it's a specific provision in subsection H,
Yes.
which in fact has quite a long legislative history, because it was always there.
As does B. Admittedly, B is I can see some anxiety possibly attaching to B because it's such a wide provision, but one could read it as only supplying the duty of confidentiality of the persons to the extent that the civil proceedings require.
Probably a Aaron, it just occurred to me, don't all the problems about the individuals making a disclosure once there is a Norwich Pharmacal or Shapiro order get coped for by the exception at the beginning of 2, except for the purpose of the performance of his duties? If the bank has been ordered to make a disclosure, then the individual who actually does it is performing his duties, namely to the bank, which itself is under a duty to disclose the information as a result of the court order.
What the words under the banking laws govern?
Well, I was read them as governing only exercise of functions.
Yeah.
My Lord, we would accept that point, absolutely,
I'm just playing devil's advocate. 1A envisages that the person will perform duties under the banking laws. The sort of closing words of 1A.
That's when he defines when he has to take the oath.
Yeah, but he has to do it. He has to take, yes, exactly. He has to take the oath before he begins to perform any duties under the banking laws.
I think we decided there wasn't banking laws is not a defined term, save that we're told it includes.
It's only defined, it's only what it includes.
Yeah.
No. Where we had got, with respect on our written case, is at paragraph 82 of our written case, 64(3)H. Where is it from? My Lord, I am being told, my Lord, Lord Underhill, that banking laws is defined. It's not in your Lordship's bundle, and I can read it out to your Lordship. It was amended by Act number 9 of 2019. Banking law means this Act, so that's the Banking Act, the Bank of Mauritius Act, the Convention for the Suppression of Financing of Terrorism Act, the Financial Intelligence and Anti-Money Laundering Act, the Prevention of Terrorism Act, the Prevention of Terrorism International Obligations Act, and the United Nations Financial Prohibitions, Arms, Embargo and Travel Ban Sanctions Act 2019, and includes such other enactment as may be prescribed.
It would be excellent if we could have a copy.
Of course, I apologise. So where we had got to, and I take on board your Lordship's observations this morning, we are of the view that there is no good reason to restrict the provision just to natural persons who act for the bank rather than the bank itself. And those are the points that I made at the beginning. The bank obviously can only act through natural persons, so how does the prohibition operate if it doesn't bind the bank itself? If the Supreme Court is right, Section 64(2) wouldn't actually impose confidentiality on the bank itself, but only on its agents. The Supreme Court accepts that the bank owed confidentiality duties to its customers. There's no issue on that. And we do say it would be incoherent if you come within 63H by summoning the bank's officers, but not summoning the bank itself, who would appear by its officers. And we do say that the section on our reading was intended to and gives effect to the Tournier principles, or equivalent French principles. And we rely on all the cases set out in our written case and the helpful summary in the bank's written case at paragraphs 23 to 28, which is at page 552 of your Lordship's bundle. And we say there is a long history of the Mauritian courts taking this approach. And in effect, Section 64(3)H provides that banking confidentiality doesn't apply in the face of a court order that somebody is summoned. And that ties in with respect to and the persons listed in 63(1) will only have this confidential information as a result of their relationship with the bank or by reason of acting as agents for the bank. And it would be perverse, we say, if the secondary holders of the information having obtained that information from the bank, who are the primary recipients of that information, that the bank wasn't captured by 63(4)H in the same way as the individual agents or employees are. My Lord, that's all we have to say on ground 4. And Mr. Sanasi was going to deal with ground 5.
Yes, Mr. Sanasi.
Section 64, by its history, has always given quite a lot of difficulty. And one of the issues we face today is because it has been extended to the bank, although on the face of it, it doesn't refer to the bank. If I may, if I may just take your lordships to, before I turn to the ground I'm meant to deal with, the decision in Barclays Bank and Caramat, which is at page 1066 of the bundle.
Page
1066.
Thank you.
This was an interesting application because it dealt with the Mariva injunction. But in addition to the Mariva injunction and the order, my lords, it's at page 1066, and the part of the judgment dealing with disclosure, the disclosure order starts at 1073. In addition to the Mariva order and the disclosure order to police the Mariva injunction, there was also an application against banks and insurance companies for Norwich Pharmacal relief. And at page 1074, the last two paragraphs, just before final conclusion, final conclusions are the ones I wanted to draw your lordship's attention to. Now, A, the judge grants Norwich Pharmacal relief in the application. He also says, he refers to the duty of confidentiality imposed on Mauritian banks by Section 64 of the Banking Act, which is an extension of the provisions to the bank, although on the face of them, they apply only to the employees. And then he summarizes the principles for Norwich, for the granting of the relief. But this would be, and is one of the judgments we relied on in asking for relief in this matter. Now, and which is why we also say that the distinction sought to be made with respect to 3H, insofar as employees and the bank is concerned, it can't work both ways. It's either the provision doesn't apply to the bank, in which case relief can be granted, or if the provision applies to the bank, then the exception under 3H would also extend to the bank. And quite apart from the example which Ms. Previs has given to you, the other example is simply that when we would summon someone to give evidence on banking information, the summons would be issued to the bank to depute whoever they would deem fit. It wouldn't be directed to a particular person. I propose next to turn to the ground appeal I meant to be dealing with, which is 6410. Now, the issue turns on the interpretation of 6410. In particular, whether only a public authority listed in subsection 9 may trigger subsection 10, or whether subsection 10 is a wider application and could accommodate the applicants. Your lordships will find the subsection in the bundle at page 635. Importantly, before I deal with the wording of the statutes, the issue as we see it is not whether subsection 9 can only be read with subsection 10, which is what the Supreme Court in the judgment seems to imply, but rather whether subsection 10 can be read on its own without subsection 9. Now, Lords, there are three alternatives which have been suggested to the court as to the reading of subsection 10. One in the judgment, that subsection 10 only applies to the public authorities listed in subsection 9, and your lordships will find this in the record at page 343. This is said to result from a reading of the Act as a whole. This was also the approach in Fundam and Banque des Mascareignes, based on the fact that the or only appears between paragraphs B and C of subsection 10. The decision in Fundam is at page 1142 of the bundle, and this is dealt with specifically at internal page 6 of the judgment. It's at page 1147 of the bundle. The second alternative reading which has been suggested was the one taken by AfrAsia before the lower court, which was that A, B, and C had to be read cumulatively. The or had to be read as an and, and this is at page 306 of the record. The third alternatives, my lord, is the ones which the appellants suggest, which is subsection 10 can be read independently of subsection 9. The or at the end of the penultimate paragraph should be relevant and read as being at the end of each paragraph of that subsection. Now, Lords, in addition to what is said in the stated case of the appellants, we would submit that the third interpretation, that subsection 10 can be read independently of subsection 9, is the better one for 5 reasons. 1, this interpretation is supported by the structure of the section as a whole.
By the section, you mean the whole section?
The whole section as a whole. Subsections 9 and 10 are 2 separate subsections. If 9 or 10 had to be read with 9, the provisions in 10 could have been included in subsection 9 as a subparagraph. This is not how the provision is drafted. The second is that this interpretation is supported by the structure of the subsection itself. So I've looked at the section as a whole. Now, if we look at the subsection itself, paragraph, sorry?
9 or 10 or both?
I'm sorry, I'm looking at subsection 10.
Right.
The interpretation is supported by the structure because paragraph A should have been in the opening words or the chapeau of the subsection if it were to apply in every case rather than an alternative to B or C. The provision could have very simply have read, the judge in chambers shall not have made an order of disclosure unless he is satisfied that the applicant is acting in the discharge of his or her or its duties, and A, the information is material to any civil or criminal proceedings, or B, the disclosure is otherwise necessary in all the circumstances. The point is, it didn't need to be a separate paragraph in the subsection for it to apply in every case. It actually should have been in the opening words. Third, the interpretation is supported by modern drafting practice. Where a provision consists of several numbered paragraphs with the or at the end of the penultimate paragraph, there is a very strong implication that each preceding paragraph is separated by the same word. In this case, the disjunctive or. And it is our submission that there is nothing to displace that drafting practice. Four, the interpretation takes nothing away from the operation of subsection 9. Although this is already stated in the written case for for the appellants, the judge in chambers would be able to exercise control over an application under subsection 9 in any case. It is inconceivable that the court would grant an application where a public authority listed or a public authority referred to in paragraph A would be acting ultra vires or for an improper purpose.
Can you just help me on judge in chambers?
Yes.
I mean, I have a sort of feeling I sort of understand what that means from a purely English context. And I'm obviously tempted to assume, because of Mauritius having got most of its procedure from an English context, that I can rely on what I think is the relevance of limiting all this to a judge in chambers. Yes. But what I find slightly odd is, if 10 is freestanding, why is it only the judge in chambers who's constrained by these three conditions?
Yeah. I'd like to add to that, also why is a definite article used rather than the indefinite article?
Right. So, two questions, Lords. The judge in chambers, as I understand it, is simply a jurisdiction of celerity. The judge in chambers is a judge of the Supreme Court. He exercises the power of the Supreme Court. He intervenes on matters which are urgent, either the usual injunctive process or Article 806 under the Mauritian Civil Code, where urgent relief is required. But there is quite a body of case law from the board itself, Tumani, and which is cited in Tumani itself, where the Supreme Court, where the board has told the Supreme Court not to be overly technical over the jurisdiction, because it is ultimately simply a jurisdiction of celerity, is my submission. The second point, because this was raised before the lower court but hasn't been made an issue before the board, is the reference to the judge in chambers here, whether it would prevent the open court from dealing with it in that way. An interesting example I would take would be Section 73 of the Courts Act, which deals with injunctions. Traditionally, applications for injunctions go to the judge in chambers, and then they can go to the open court. But no one would suggest that we couldn't go on a motion Monday and apply for an injunction before the Chief Justice. No one's made the point, I think, because it's a thoroughly bad point. And so even if the judge in chambers can make it, it doesn't mean that the open court can't do it.
But here it's a prohibition.
Yes.
10 isn't conferring a jurisdiction, it's just telling us when the judge in chambers can't do something. Right? And it sort of conjures up the, I think, rather Gilbert and Sullivan possibility of being able to get around the prohibitions just by going in open court on a day when nobody's there to be tipped off about what you're up to.
Well, that's... I wouldn't necessarily see it that way, because the subparagraphs are wide enough to cover all of the exceptions, which would be covered in 20 and the duty to the public as well. So if we look at A, B, and C as alternatives, then the jurisdiction of the judge in chambers isn't really constrained. Now, why the judge in chambers? A possible explanation is that traditionally these applications in Mauritius have always been made to the judge in chambers. At least they were under the old law. And that would be referred to in the case of Rojwa, which has already been referred to before the court. And this provision, which existed in the old law and is simply carried over now, simply refers to the jurisdiction of the judge in chambers still, would be our reading of it. Lord, as to the point, to the determinant there are two ways of reading it. One would say it refers to the judge in chambers under 9. That is one way of reading it. The other one would be that it refers simply to the jurisdiction of the judge in chambers.
Then you would say a judge in chambers. Not natural, anyway.
Yes. But the point I would want to make is that the reference to that would be to the jurisdiction itself. It didn't necessarily mean to a judge in chambers. It is capable of both readings. And in this case, it brings me to my last point.
I think when I was at bar school, I was probably taught that if you wanted to make an urgent application in what was then the Queen's Bench Division, you applied to the judge in chambers, because on any given day, there would only be one.
Yes.
Rather than any old judge and ask him to sit in chambers, it would be a particular nominated judge doing all the interim applications in chambers, opposite in Chancery as well as an open court.
Which has also been rather the practice before our courts too.
Yes.
Which would be a judge in charge of urgent matters on a particular day. Of course, the commercial judges, unfortunately.
But then why does the draftsman refer in 9 to an application to a judge in chambers, and then use the language of Lord Briggs's youth in subsection 10?
Yeah.
Yes. Lord, as I said, it's, our submission is that it's capable of alternative readings, and which takes me to the last point, which is if there is an ambiguity, the interpretation then, which we suggest is supported by the presumption against legislative interference with legal rights of process. Again, access to the courts is a fundamental constitutional right in our jurisdiction, and litigants should not, without clear authority, be shut out from the seat of justice. The interpretation adopted in the judgment deprives the appellants of any private law remedy at all. And in the event of an ambiguity, we would submit that 10 should, in our submission, be interpreted in a way which advances the rights of access, as opposed to stifling them. I'm much obliged, Lord. This is what I had on this point.
Thank you very much, Ms. Massey.
My Lord, those complete our submissions.
Thank you very much, Ms. Revisa. Mr. Person.
Yes, my Lord.
Lord, as our learned friend appearing for the appellant has indicated, the respondent did not object to the prey assault before the court below. The thrust of the argument of the respondent was that the order could be granted under section 64(3)(h). Hence the reason why before the court below we reached the conclusion that there was no need to invoke the Norwich Pharmacal order. And thirdly, the point which was made on behalf of the respondent before the court below was that clearly section 10 could not be construed on its own. It had to be read subject to subsection 9. The submission on behalf of the respondent, my Lord, are to be found at pages 548 to 549 of the brief. Your Lordship will note that we tend to agree, if not we agree with the appellant on ground 4 and ground 2. I'm tempted to say that we partly agree with the appellant on ground 1. I say that because if your Lordship is right, and I have observed the comments of your Lordship, if your Lordship is right in thinking that section 64(3)(h) does not apply to the bank, then I agree with the submission of my learned friend for the appellant that they would then be entitled to resort to the principle enunciated in Norwich Pharmacal. Hence the reason why I say we partly agree with the appellant on ground 1. Now, we do not agree with the submissions made on ground 5. Well, perhaps to deal with ground 1, I was tempted to say that I was not going to quarrel with your lordship on the interpretation of section 64.3h. But I need to perhaps make two observations. Honourable friend Sanasi is perfectly right in saying that perhaps invariably the summons is not issued on the officer of the bank. The summons is issued on the bank, so that it makes no sense to say that, well, 64.3h applies only to the officer and not the bank. That is the first observation I wanted to make. The second observation I wanted to make, my lord, is with respect to the authorities which we have referred to. Now, your lordship will see that we have referred to the case of Rojua. At paragraph 23 of the written submission, at page 552, and which case is reproduced at pages 1172. Now, I mean, from Rojua, the case of Drouin, the case of Li Teng-sang, my point will be that in the views of the judges of the Supreme Court, there has been no doubt that in those cases, although the summons was issued on the bank, your lordship will see that orders were made by the judges. Now, in the case of Rojua, the application was made under section 39 of the previous legislation, the 1988 legislation. That is a case where an order was sought under section 39(2)(d), and where the order was sought against the bank, and his lordship, Mr. Balancy, issued the order in terms of section 39(2)(d). Now, I am perfectly alive of the fact that at that point in time there was no such thing as 64(1), right? But could the legislator have substantially departed from the position as it was under the 1988 when the 2004 Act was passed? My submission is that it could not have been the intention of the legislator that the law had to be changed. So, your lordship will see that subsequent to the case of Rojua, there was the case of Drouin, which we refer to at paragraph 25 at page 553 of our submission, and which is also reproduced at page 1079 of the brief. Now, your lordship can bear with me. Now, Drouin is a case where, again, your lordship will see that the order was sought against the bank. And this is the case where the applicant was seeking an order fairly similar to the orders being prayed for in the present case. Now, the court at page 1082 said this: with this, I had dwelled a little on the legal basis. This application has been made under Section 64 Banking Act. The subsection has not been mentioned, but when requested to indicate, the applicant relied on Section 64(3)(d) and (h). Now, Your Lordship will see that the judge then referred to Norwich Pharmacal, and then at the end of the day granted the order. The point I want to make is that although we had moved from the 1988 to the 2004 Act, the Supreme Court in its mind had no doubt that the principle as was enunciated in Rodua continued to apply. Now, subsequent to Drouin, there was the case of Lee Teng Sang, which is a 2014 case, and which was referred to paragraph 43.
Can I just interrupt you for a moment, Mr. Persam? I see that section 39 2D of the 1988 Act was in different terms from the current section 64(3)H. If one looks at the 1988 Act on page 599,
yes, my Lord.
One sees under subsection 2, the duty of confidentiality imposed under subsection 1 shall not apply where D, a banker is summoned to appear before a court or a judge in Mauritius court, or the judge orders the disclosure of the information. So that's a very straightforward provision.
Indeed.
Now, under the current legislation, instead of the word or, one has the word and. And the court, so the person is summoned to appear before a court or a judge in Mauritius, and the court or the judge orders the disclosure.
Your Lordship is perfectly right.
Yeah. So
it says or.
It's less. So the wording is less expansive than it was before. There always has to be a summons for the banker to appear.
Yeah, strangely enough, as Your Lordship indicated, in the 2004 Act, it says, and the court orders the disclosure.
The authoritative version has the and, we're told, not page 594 in 598. It's been struck through, unfortunately, but you can see it says and Article D. So.
Oh, yeah.
Yeah, I think.
And the court or the judge.
Okay, well, thank you for clarifying that. So,
I'm grateful to my learned friend. In fact, the original version of the Act shows that it was and.
yes, so what we have on, just to be clear, what we have on 599 is some sort of official version, but it's agreed not to be accurate. Is that?
No, it is the version used on the Supreme Court website, but it is the one used currently, because it's regularly updated. It's not actually the official version of the Act or the revised.
Right. Thank you.
Hence the reason why, my Lord, why both versions have been placed before Your Lordship, but the official version is indeed, as my learned friend has indicated, at page 594.
Thank you. Well, I'm grateful for that being clarified. I won't take up more of your time with that point, Mr. Person.
As I indicated, my Lord, although I do accept that the wording insofar as Section 64 is quite distinct from the wording of Section 39 of the previous legislation. The point I was making is that my submission is that it could not have been that the legislator wanted to depart substantially from the position that that was the case prior to the enactment of the 2004 legislation. Now, I was taking Your Lordship to the case of Lee Teng Sang, case of 2014, which is at paragraph 43, page 555 of our submission, and which is reproduced at page 1135 of the brief. Now, again, Your Lordship will see that the order sought for was against the bank, not the officers of the bank. The prayer was fairly similar to the prayer being sought for in the present case, because the aggrieved party was seeking disclosure from the bank in order to trace the funds which had been defrauded. The court, at page 1138, my lord, middle of the page, say that the present application is statutorily based on section 64(3) G and H and 10 of the Banking Act. Now, the learned judge then alluded to the principle in Norwich Pharmacal and then issued the order prayed for. Now, those three authorities, my lord, tend to show clearly that all the orders were sought against the bank pursuant to section 64(3)H. In all those cases, the court acceded to the order prayed for. Now, the last case which I wanted to draw your lordship's attention is the case of Nandu Singh, which is at paragraph 31 of our submission, page 554, and which is reproduced at page 1164.
I see the time, Mr. Person. Could we look at this case after the short adjournment?
Indeed.
Very well. I wonder, it'd be very helpful if somebody could just check. I mean, given that it turns out that the version of legislation we've been looking at isn't actually an authoritative text, could somebody kindly check that the 2004 version that we have is correct?
Yeah.
Thank you very much. We'll adjourn now till 2 o'clock.